appreciate the opportunity to testify today. Senator Clark, members of the committee. My name is Jennifer Levi. I'm the Director of Transgender Rights Project, Gay, Lesbian, Advocates, and Defenders. I'm an attorney who receives the calls from transgender people who face discrimination and harassment and public accommodations. I've also testified before this committee several times in support of the legislation that was ultimately adopted in 2011. I'm sorry that Representative Harrington isn't here today. Isn't here at this point to hear me reiterate what Commissioner Tynes explained, which is that the original bill, transgender non-discrimination law that was submitted to this committee, was included protections for employment and pursuant to Chapter 151B, education pursuant to Chapter 76, as well as the public accommodations pursuant to Chapter 272. The public accommodations provisions of 272 were stripped from the bill that was ultimately passed. And so we are back before this committee to ask for the law to be made whole and complete to protect transgender people in all walks of everyday life, including access to facilities that are open to and solicit the patronage of the general public. That's the way public accommodations are defined in Chapter 272. There are 17 states, including Massachusetts, as well as the District of Columbia, that have comparable protections. It's only Massachusetts which does not have express protections for transgender people within those set of states in the context of public accommodations. I do understand that there may have been some misunderstanding at the time, and some opposed the law, although most did not, I believe, because of the ways in which it ensured equal access to transgender people in the context of bathrooms. The law that was passed did not create any exceptions for bathroom access for transgender people in schools or in the employment context, which is why the guidance that was issued by the Department of Elementary and Secondary Education is consistent with the terms of the law. I do understand that notwithstanding that, there are some people who would oppose equal access for transgender people in restrooms. Any rule other than the one that has been adopted in the context of employment and in the context of schools is unworkable. And I know that a number of members of this committee worked very hard to ensure that the definition of gender identity did not protect anyone who is asserting a gender identity for an improper purpose. That's expressly within the language of the definition, and that's the same definition that would be incorporated within the provisions that would add into the law protections for transgender people in the context of public accommodations. It's the only workable rule, and we ask this committee to support House Bill 1589, Senate Bill 643. The law would protect the transgender woman's access to the women's restroom. And as I said, the definition ensures that that means only someone who can assert a female gender identity for anything other than an improper purpose would be protected under the law. That is comparable to the same rule and law in 16 other states, plus the District of Columbia. The federal government has issued guidance that reiterates the comparable rule. It's the only workable rule. Requiring a transgender woman to use a men's facility would effectively mean that she's excluded from using that changing facility. Requiring a transgender man, someone who has a bald head, full beard, to access the any restroom other than the men's restroom or the men's changing facility would be unworkable. Representative Lyons spoke about how an 8-year-old girl would respond. It happens that I'm here with my 8-year-old daughter. And I asked her, about this, and what she said, and she's certainly had this experience, that if she is using a facility with another person who is a girl, that she would be perfectly comfortable with that. I also recognize that there are some people who are unfamiliar with this issue who may well be uncomfortable sharing a facility with someone whose life they don't understand. The purpose of non-discrimination laws has always been to work to change attitudes, including attitudes that are based on discomfort that leads to discrimination and exclusion of people within our society. It is certainly true in the race discrimination context that exclusion of others from using basic daily facilities like a water fountain were rooted in the discomfort of having to share, having people of different races share the same water fountains at a time when people didn't understand that those differences of color didn't import any meaningful differences in the social sphere and shouldn't do so. In the context of passing sexual orientation and non-discrimination laws to ensure that gay people would be fully integrated into society. It certainly was raised, it was exactly at the heart of the military exclusion, a concern about gay people sharing locker rooms with non-gay people. We're looking to this legislature to set the tone of leadership and indeed to support the change in cultural and social views to ensure that transgender people aren't excluded from access to the very daily kinds of facilities that people have access to, stores, malls, shopping centers, movie theaters, and yes, locker rooms and bathrooms. The city of Boston is one such example that has had express protections, for example, in the housing context now for over a decade. And the report that we get back from the city of Boston and other local areas that protect on the basis of public accommodations is that it has the only people whose lives have just changed is the transgender people who have been guaranteed access. It's harmed no one, and there have not been complaints about this.